Okay, welcome back to Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us. What an outburst that happened just now in the Scott Nelson courtroom. As you know, we are live in day 3 of the penalty phase for the man who was convicted of brutally murdering Jennifer Fulford. The jury will have to determine his punishment, life in prison or the death penalty. There was a witness on the stand who was discussing Mr. Nelson's life in prison, and at one point, he got upset for the implication that he is a racist. So let's play this outburst that happened in court earlier.
Isn't outside the scope of this witness's expertise?
Madam Court Reporter, can you read back the question?
Mr. Nelson has shown no adverse effects for the social housing act.
I'm sorry. Mr. Nelson, you need to take a moment. Mr. Nelson, you need to take a moment with your attorneys. Hold on, sir. Sir. Members of the jury. Mr. Nelson. Mr. Nelson. Mr. Nelson. Are we clear that you're going to stop talking? I need a verbal affirmative.
Yes.
Mr. Nelson, talk with your attorneys, and then your attorneys. I'm going to, Mr. Nelson. Mr. Nelson, Ms. Simmons has asked for a moment to talk with you privately. I'm going to grant her request, and you're going to have that opportunity. You need to follow the deputy's instructions so they can facilitate this. Okay, go ahead.
Wow, so he basically was not happy. Said that this is out of control. He said, put me up there. I want to testify, indicating that he will speak. He will make a statement. He will testify during the penalty phase. I'm back here with former senior judge and attorney Judge Gail Tusan to break this down. Judge, is this grounds for a mistrial? I mean, for the penalty phase?
No, we're not anywhere close to a mistrial at this point. All he has really done is to protest the testimony that he's heard thus far. So I think the jury would understand that if it's not favorable testimony, that he would disagree with that. So in my opinion, he hasn't tainted the process, but he is interfering with the process, and the judge has to absolutely maintain control.
Is the judge going to make a statement to the jury after, please disregard what you heard, or give some sort of instruction?
I didn't hear him, again, to have said anything that would adversely influence their consideration of the evidence. I mean, for him to say I'm not a racist, well, that's his opinion. The jury will make their own decision as to whether he is or isn't, and will be instructed on whether or not he is a racist, whether that's relevant or not to the case. So I don't think there are going to be any instructions given to the jury other than reassuring them that we've had a break and we're ready to proceed.
Look, when he took the stand during the trial phase, it was all about how he felt he was justified for murdering Jennifer Fulford. Do you think when he takes the stand in the penalty phase, and all signs are pointing to him to do that, is it all going to be about, this is who I really am, this is what my life is like, this is misconceptions that the state has been putting forward?
I don't have any confidence that he necessarily appreciates the distinction between the guilt and innocence phase and the penalty phase. So we should anticipate that any opportunity that he has to speak, he's going to say whatever he wants to say, and that there will be objections, trying to, constrain what he's saying to the purpose of the penalty phase.
Interesting. Well, I'll tell you what, let's go back to when he took the stand earlier on in this case. We'll play it for you right now. All right, we're jumping out of this. There's some activity in the courtroom. Let's go live.
Any issues at all, sir? I'd just like to proceed. And I was getting into my feelings, I guess, and say it won't happen again.
You recall our conversation previously when you made an objection, I believe. Do you recall that conversation?
I do, Your Honor.
Do I need to repeat that conversation, or did you just forget what I said?
No, I remember very well now. Won't happen again, sir.
Do you understand, although you're on trial here?
Yes, sir.
That if you violate the court's orders and you do not conduct yourself in a manner in accordance with the court's orders, which includes but is not limited to the decorum policy, that you can forfeit your right to be present during your trial, and I can have you removed from the courtroom. Do you understand that?
Yes, I do, Your Honor.
Have you had a chance to talk with your attorneys about that?
Yes, I have.
At this point, you've engaged in 2 outbursts. Are you confident that you can comply with the court's orders and continue to do as you've been doing, which is sit here at the defense table, work through your attorneys privately in private conversations to convey your desires to them as you have been doing, and otherwise speak only through your attorneys unless the court asks you for a direct response? Do you feel confident you can do that as we proceed?
Yes, sir.
Do you need to talk with your attorneys or talk with the court about any clarification on what the court's expectations are regarding your behavior here in court?
No, sir.
Okay, the judge admonished the defendant once again. This is the second outburst. He gave him a warning. He says you're in dangerous territory of forfeiting your right to be present. Judge, how did the judge handle this?
Still gets an A+ in my book. I anticipated that, we're escalating at this point. He's been warned. You just need to keep warning him. He's not listening. The defendant is not listening. He has his own agenda, and unfortunately, he may miss out on being able to firsthand see what's going on in this phase. He could be escorted out and not permitted to return.
Well, we'll have to see if that happens. Let's take a break, and who knows what we can expect in this courtroom. Stay tuned.